Hello, I'm Richard Harrison. I'm a barrister at 1 King's Bench Walk.
And I'm a solicitor, Katherine Gieve, now retired from Byman Solicitors.
And Katherine, we're going to talk a little bit about the future of children law.
I think the first question really is, for you, what do you think the impact of Brexit is going to be?
Well, that's the big unknown, isn't it? We're filming this on the 22nd of October, which is 9 days before the 31st. The 31st in the current legislation is described in rather dramatic terms as exit day. 11 p.m. on the 31st, as matters stand, is the date on which the Brussels II revised regulation, amongst other European legislation, will fall away entirely and be repealed. Now, assuming there is no change between today and the 31st, and there may well be, the consequence of that regulation being repealed is that the rules we have become accustomed to for the last 16 years or so in dealing with jurisdiction in relation to children, the enforcement of orders made by other EU member states in relation to children, will all disappear, and we're going to have to become accustomed to a completely new regime. The governing instrument after this falls away, or the main governing instrument, is going to be the 1996 Hague Convention, which, although familiar to family lawyers, is a lot less familiar than Brussels II revised.
So if there is a deal, what's going to happen then?
It rather depends on what deal is done, but if there is a deal involving a transition period, the assumption is that everything will remain as it is during that transition period, and so there'll be no big change on the 31st of October. There may be big changes further down the line, because it's assumed that at some stage or another the European legislation will be repealed.
But at least there'll be a bit of time then to prepare for it.
Yes.
When we know slightly more clearly what's going to happen.
Yes. Although the jurisdictional rules will be replaced by a different set of rules, there probably won't be that dramatic a change in substance, in that the main rule of jurisdiction under Brussels II revised and under the 1996 Hague Convention is habitual residence. And so in the vast majority of cases that come before the English courts, jurisdiction is determined by reference to the child's habitual residence, and so that's not going to change. Where you will see changes are in some of the subsidiary jurisdictional rules. For example, the Article 12 jurisdiction under Brussels II, which allows, in certain circumstances, jurisdiction to be prorogued to another member state where the child might not be habitually resident, doesn't have an equivalent under the 96 Convention.
So, and I think it's important not to underestimate the impact of this, because one of the things we've seen over the last 30 years of the Children Act has been a massive increase in cross-border litigation about children.
Well, that's right.
Because of the mobility of parents and families.
Yes.
So I think it's really going to be quite a task.
It will be quite a task, and it's perhaps most relevant when courts are being asked to enforce orders made in other jurisdictions. We've all become accustomed, haven't we, to the rather streamlined method of enforcement that exists under Brussels II revised. And although the 96 Convention, and there is another Luxembourg Convention that can be used in cross-border enforcement cases, will be there as tools for the courts to rely upon, that neither of those instruments is quite as streamlined as the Brussels legislation. What other changes do you see in children's law going forward?
Well, I think the technological and the medical changes are going to continue to be important. I mean, we've seen the impact of the law relating to surrogacy and we've seen the combination of the surrogacy law and same-sex parenthood and how those integrate. It's difficult to know exactly what's going to happen next, but I think I think that the technological changes in possibilities of conception will lead to other changes in the law, and I think we see that in this recent decision about whether a trans man who gave birth to a baby could be registered as the father of the baby, or was to be registered as the mother of the baby, and that was a question of the Birth and Death Registration Act, the human rights questions, and also the Gender Recognition Act. So there's a lot of complicated law going on there, which is reflecting the changes in the way people are leading their lives.
And do you think the existing legislation is sufficiently flexible to cope with future technological developments?
I anticipate that there will have to be changes in the law. I think that I don't think actually that the present law does sufficiently recognise the social changes, and so I think Parliament will have to have a look, as well as judges doing their best to cover the new circumstances.